Welcome back to another episode of ACA Cast. With your host this week, my name is Alex Szeto. ACA Cast is the official podcast of ACA International, the leading voice of the accounts receivable management industry. Before we start today's episode on mitigating litigation risk, the content provided in this podcast is presented for education and general references only. The content is not intended to serve as legal advice. Third-party content is not endorsed by ACA International, nor does it necessarily reflect the opinions of ACA International. Joining with me are two industry veterans, Heath Morgan of Morgan Financial Group and Shannon Smith of LitLogic. They are both presenting in the upcoming hot topic, Optimizing Your Operation to Manage Litigation Risk, on March 5th. For more information, go to our website or it will be in the show notes. Thank you for joining with us today on ACA Cast. How's it going today?
Hey, Alex. Good. How are you?
Going good, Alex.
Great. So can you help our audience understand how they can mitigate their risk? And can you provide a couple of examples of what they can do to mitigate such risk?
Well, that's a broad topic that we're going to try to cover in an hour or hour and a half in a couple of weeks. I think from a general perspective, as we look at the issue of how you actually manage risk in our industry, there's no way to eliminate risk completely. The best case scenario you can do is just look to ways to reduce that, to use the term of a low-hanging fruit, to not make yourself low-hanging fruit to plaintiff's attorneys and plaintiffs counsel. First thing I'd say from a broad perspective is just as agencies' compliance management systems have gotten more sophisticated over the last 5 to 10 years, so too has the plaintiff's attorney business model grown and evolved over those years. Just as we do our due diligence with our litigation and scrub our accounts, they also are scrubbing their accounts for litigation. One thing they use for a quote-unquote credit report against our industry is your PACER lawsuit history. Now, you may not be aware of this, but your whole entire litigation history of when you've been sued, how many times, what jurisdictions is all available on the public access PACER federal court websites. And what information is also there is how quickly you resolve those cases. If you're a difficult litigant and you litigate all these cases, your case history can be a year, year and a half long cases. And if you're an agency that settles cases and settles them quickly, that information is also going to be available on the PACER page. If you don't know your credit report, know your credit history of your agency and how quickly you settle cases and what your average is, you should look that up online and make yourself aware of that, because if you're not aware of it, plaintiffs counsel certainly is.
I completely agree with Heath, too. That's something that we continually have looked at over the years and have tried to monitor and make sure that we have pushed our settlement amounts with, prior agencies that I've worked for out as far as possible so that we have a very long lifespan on our litigation cases, so it doesn't appear that we are settling right out of the gate as soon as something is filed against us. And a couple of ways to do that or to push out how long your case stays open. There's a couple of cool little tricks and tips that we'll talk about at the webinar. Just a few here. One is payment plans. I've done several settlements with plaintiffs counsels, and it's been a great negotiation tool and tactic to use when I'm settling with them, is asking for the payment arrangement on the settlement amount to be broken out over several months. It allows them to buy time with the court. It allows the case to drag on per se on paper or in PACER until the actual final payment has been made. And that's proven to show some longevity in our cases, at least on the PACER model, or showing the case seems to have been lingering and sitting out there for quite some time. Another thing I've done is asked the plaintiff's counsel for a waiver of service or completed a waiver of service as soon as the case is filed and sent it to the plaintiff's counsel and asked them to file it with the courts. Doing so buys you more time to review the lawsuit and see whether or not there's any merit to the case. It allows you time to go talk to the plaintiff's counsel and tell them, don't serve me, this isn't a viable case, this is one that should get dismissed because here's what we found, given that you've had more time to actually review it. Or if you have found something that's going to be problematic, it saves you on service costs. That if you do need to settle, it's one less piece that the plaintiff's counsel can add to that settlement amount. So those are just a few that have been able to proven tips that have been able to push out those cases a little bit longer than just the run-of-the-mill calling, getting service, and having the case resolved within 30 to 60 days.
So for our members that operate in high-risk states, such as California or New York, what advice do you have for them?
Oh, where to start with this one? I guess what I would say, first of all, is kind of half joking, stop sending letters to New York if you can. That's a good way to not get sued there. I'm not sure how practical that is. If it's practical, absolutely I'd do that. On a more serious note, if you do have clients and they are wanting you to still collect and send letters in New York, I think the first step is education. You want to educate your client, let them know of the risk you're taking by sending a first letter to New York. And I would also educate them with there's a chance we are going to get sued. And of course, the two most popular issues in New York are the reverse Avila interest case and the name of the original creditor and name of the subsequent and current creditor issue. What I would say to your clients for that is if you want us to send letters, make sure that we have a point of contact to be able to execute an affidavit, either one saying we're not charging interest, we're not subject to the reverse Avila issue, or to two, to have an affidavit saying this is the actual name of the original creditor and our actual name of the current creditor. And you're going to want to have that handy because you still will probably get sued in New York, just the nature of it right now, unfortunately. But you can have those affidavits from your clients ready, and whether they'll move the needle with the plaintiff's counsel with bar shape offenders, they may not. Your first status conference with the judge, if you have that affidavit ready and you're telling the judge that you already gave this affidavit to opposing counsel and they're ignoring it, that's going to help you get rid of that case a lot quicker.
I completely agree. That and reviewing what's going on with plaintiffs' counsel's cases in these high-risk areas or states where we see mass filings done by the same plaintiff lawyer over and over again. Oftentimes what's really impacted our decision on whether to litigate or how to handle the case once it's filed against us has been to look at what the plaintiff's MO is, the plaintiff's counsel's MO, I should say, is. So are they filing class actions but always settling on an individual basis right after a case is filed? How long is it taking for all of their cases? Looking at through PACER at what they file. Do they file discovery right out of the gate, or are they just sitting on cases and not responding? Oftentimes, you know, and I'm sure in our webinar we'll get into several plaintiffs' counsels not having their plaintiffs appear, or even the plaintiffs' counsels not appearing for certain court cases. And out here in California, where I'm at, the court requires everyone to appear at an E&E conference or early neutral evaluation conference, and that's a great way and tool to get right in front of the plaintiff and see if the plaintiff will even appear. So sometimes looking at what the plaintiff's counsel's typical MO is, what the courts typically require in some of these high-risk states, or looking at even the courts themselves. Do they accept motions to dismiss? Are those granted typically? Are they not? Some of these things, if you can find out early enough, it can save you a lot of time and money in what you also provide or tell your defense counsel to do for you. If it's a complete waste and it's not something that the court typically allows, it could be something that you bypass completely and find another alternative in handling some of these high-risk states and their plaintiffs' counsels.
I think the only thing I would add to that is going back to the first letter internally, I would recommend eliminating a second letter or third letter to be sent to those states currently until the case law is developed or until these judges in these courts are sick enough of these cases to start kicking them out earlier.
So consumers are communicating with various methods that includes text messaging, instant messages, and other technological advances. Can you help us understand what agencies should look out for in terms of risk when communicating with consumers using these technologies?
Yeah, I think social media obviously has become a forefront and definitely changed the way our industry is interacting and communicating with consumers. Obviously, we've seen a huge shift in availability of not just letters and calls anymore. Consumers are contacting agencies through Twitter now and social media sites all over the place. I think it's very important for agencies to be careful and manage their brand. If your company doesn't have these avenues set up, a Twitter account, a YouTube channel, using Google AdWords to make sure your company is on the forefront of the Google pages so that consumers find out about you from you and not from other sources, those are incredibly effective tools to getting consumers to go to your website versus others. I think agencies should really watch for those credit repair sites or consumer complaint sites where people are putting in your phone numbers and saying, who is this agency? And there's a lot of either professional plaintiffs, say, or other consumers, or there's professional bloggers out there that have a lot to say on the internet, or even plaintiffs' law firms get on there and respond and start responding back to inquiries about your company. If you're not responding to those and giving out a company message, even if it's vague, you know, here we are, this is who we are, here's our link, or call us directly at this number and we'd be able to help you with whatever concern or question you have. If you're not responding for your agency, somebody else will. Unfortunately, sometimes will be a plaintiff lawyer, it will be a plaintiff or a pro se plaintiff. Really, you want your company to have its own voice, and certainly being aware of what social media outlets are out there in order for you to be the first to communicate and talk to consumers and provide your own message, I think is critical and important to all of our agencies within our industry.
Yeah, Shannon's right to more of a consumer-friendly, consumer-focused model to where not only is our front and our appearance, you know, looking to be more consumer-friendly, but we're also looking to be more consumer-friendly in our communications. And that really is the whole purpose of why agencies and the industry is moving towards texting and emailing. Because if you look at it, and we'll go into this in the webinar, relatively new and little litigation out there on the texting and on emailing. One thing about that is I attribute that to the fact that this truly is a consumer preference. I would say that one trend we are seeing with email litigation is as you build your email and texting programs, are sending out first letters or first text messages or first emails during the initial 30-day notice, you want to make sure that every link and every web page that you're directing them to on the website is going to have the validation language on there, and it's not going to appear to overshadow the consumer and the right to dispute the debt. That is the litigation that we've seen, is links to websites that overshadow the initial demand letter. And so if you're implementing those programs, you want to make sure you're compliant with that. Looking back to the bigger picture of consumer preference, right now the industry is actually in a nice little sweet spot in that there is very little litigation based on texting and based on emailing, despite how prevalent it is already in our industry. As I mentioned, it's because consumer preference. But the converse of that is also true. If you are emailing and texting consumers and they are telling you to stop contacting them that way, I would absolutely heed that warning. Because if you don't, I guarantee we're going to see a spike in litigation. You want to make sure that you have policies, procedures, training programs in place to capture that feedback, to capture the quote-unquote revocation of email consent, revocation of texting consent, and be able to honor that and make sure you're not going to bleed that over and confuse that with other accounts. Because I would say even if you have multiple accounts with one consumer, if you're texting with them at one point in time and they say stop, and then you get a new account coming in, even if you have that consent, I'd be very concerned and very mindful about reaching out to them again through text messaging if you have a previous record of revocation on that.
I agree, and I think it's really important to even have just regular reviews of all of your written communications and any materials that are accessible to the public, including websites and job postings. Like you said, he should either be in a policy and procedure to make sure that it's spelled out very clearly as to what the expectations are and how to protect the agency, and then some of the descriptions on the website really should be very fine-tuned and finessed to make sure that it's complying with federal and state laws.
Is there anything more else you'd like to add?
I think for me, I would just add that, we've got a lot to talk about. It should be a pretty engaging, pretty information-packed webinar coming up, and I'm looking forward to speaking with Shannon again.
I completely agree. I think we've got plenty of little tips, tricks. I can't wait to kind of spill some beans and give people some real direct feedback.
Thank you, Shannon and Heath, for joining us today on ACA Cast.
Thanks for having us, Alex.
Hey, thanks, Alex. We appreciate it.
Our listeners can subscribe to ACA Cast on Apple Podcasts or wherever you download your podcasts so you'll never miss a show. While you're at it, if you found value in the show, give us a ratings on Apple Podcasts. Thank you for listening today, and we'll see you next time on ACA Cast.